been a lawyer for over 32 years. People often ask me, what is the difference between a will and a probate lawyer? In this video, you will learn what a will lawyer does, what probate law is, what is probate, what is a will, do you need a will for probate? In a probate proceeding without a will. Hi, I'm Mark. I'm a Texas attorney, and in this video, we're going to learn the basics of the difference between a will lawyer and a probate lawyer. What is the difference between will and probate lawyers? The idea of a will lawyer is actually referring to an attorney that assists in estate planning prior to your passing. You evaluate the nature of the assets in your estate and make a plan regarding the transfer method, whether you're going to execute a will or a trust, or rely on Texas laws of descent and distribution, commonly referred to as intestacy. A probate lawyer, on the other hand, is someone who is required to file applications with the court, whether it's to approve a will that you've executed or to pursue a declaration of heirship where no will is present. You may also use a probate lawyer to administer the estate based on a will for the beneficiaries, or you can administer an estate without a will for the distributees identified through the Texas laws of descent and distribution. In many instances, the probate process requires the entry of orders and judgments to establish your rights as an heir at law. What is probate? The phrase probate refers to a legal process in which you establish your rights as an heir in a court at law. Whether you're taking a will to court to ask the court to approve it as a legally valid and enforceable document, or you're filing an application to determine the heirs under the laws of descent and distribution. In either case, the probate process is used to establish the heirs either by will or by the Texas laws of descent and distribution. Probate only applies to estate assets that are owned in your name at the time of passing. Probate also involves identifying claims that the estate may have that need to be collected for the benefit of the heirs or distributees, identifying the debts of the estate and the creditors so that the assets can be used to resolve any debts or creditors who may assert claims against the estate. Probate also involves, after the payment of debts and after the collections of any claims that the estate may have against third persons, the ability to distribute the remaining assets to the beneficiaries under the will or to the distributees based on the laws of descent and distribution. Whether you're seeking to probate a will or you're seeking to establish your rights as an heir under the laws of descent and distribution, understand that probate is a time-consuming process because you cannot distribute any of the assets until you've dealt with the creditors making claims against the estate. What is a will? In essence, a will is an expression of your last wishes. You can prepare a will wholly in your handwriting as long as it's signed by you and establishes your intent to make your last wishes regarding your real and personal property known. A will can also be fully typed out, witnessed by two disinterested individuals that are not beneficiaries under the will, and executed in front of a licensed notary public for the state of Texas. Do you need a will for probate? The answer to that question is no. Probate doesn't refer to just the idea of a will. Probate also refers to the estate that does not have a will, known as an intestate estate. In a probate proceeding without a will, you are required to establish the heirs through what's called an application to determine heirship. You may also seek letters of administration from the court as part of that process if you need to deal with debts or collect claims owed to the estate. When you file an application to determine heirs and request letters of administration, you have to qualify as an administrator and have an interest in the case. The court can then appoint you to manage the affairs of the estate. You can also get authority after confirming the debts and the creditors have been satisfied in the estate to distribute the assets to the heirs at law, identified under Texas Descent and Distribution, also known as intestacy. That's all the time we have. The outro music is coming. See you in the next video.